Okay, welcome back, everybody. We have a special segment here that was added to the program a little bit late. We'll start the reception right after this, but Judge Newman has been gracious enough to agree to join us here to talk about her, well, really whatever it is she wants to talk about. We invited Judge Newman to live, which we had a few weeks ago, and many of you know we've created a Judge Pauline Newman Award, which we gave out, and we gave Judge Newman an opportunity to speak for about 30 minutes or so. And at live, we don't have any of the cameras. Live is not just the name, it's descriptive. Everything is unrecorded. But we felt, and after talking with Judge Newman, that her remarks were really, I felt quite powerful. A lot of people in the audience thought were very powerful. And we wanted to have an opportunity to capture it on the record. And the plan is to put this up on YouTube and to use it as part of our podcast. And we'll write articles about this, but also to just share with you, and then eventually over the next week or so with hopefully the entire industry, Judge Newman's thoughts. And Your Honor, feel free to say whatever it is you'd like to say. You have our undivided attention. Thank you for being here.
Okay, well, thank you, Gene, and thank you for inviting me to come and to talk at this important session. And in fact, it occurred to me just in listening to the previous session, not only did it bring back memories of my own time in the private sector, but it also helped me to focus, and that's what I want to talk about with us today, what the role of the court, or the courts, but particularly my court, is in this whole area, because at the pinnacle, at the peak of all of the complex commercial decisions that you all talked about just a few minutes ago, is the expectation, the hope, and the understanding that there is a structure within government, that is the judicial structure, that will get things right, that will support truth and integrity. And when we're talking about the advances of science and technology and the powerful public benefits that follow the successful completion of the kinds of issues that I just heard your panel talk about, to have in mind that these situations are not handed down from some higher authority so much as being and remaining in the control of the people, of all of you here who are affected by the courts. The last comment that I heard on this table was the comment that perhaps the courts really don't understand, or judges really don't understand, all of the things all of you cope with every day and need to resolve, need to take action as if there were a program of truth, justice, integrity, to have things come out right in the end. Because, sad to tell, I have a few criticisms along this way. Gene heard them at his prior program and encouraged me to continue to do that. I find that I will no longer conceal my concern about the Federal Circuit and how the judicial branch overall is serving, because our role is to serve the communities on which the public depends. I think there is none more powerfully involved than the areas that all of you represent. It's the courts that have the last word on the nation's well-being. We look to judicial wisdom, which in theory is supported by judicial independence, this is the nation's goal. It was the nation's goal with the Constitution and before, and here we are. And I'm sure you all know that my judicial colleagues, in response to my judicial independence, have removed me. They call it a suspension rather than removal from judicial service, but I haven't heard a case argued, haven't decided an appeal since March of 2023, and my colleagues have just extended my penalty for another year for no reason, but this is so unusual. It's never happened in the history of the nation, and there seems to be no structure for response despite the Constitution. I assume you all know the story. My colleagues decided in some secret procedure, the nature of which I still don't know, that I am physically disabled and mentally incompetent. And they told me so, and that I would hear no more cases. As you can imagine, I protested. And after I filed suit in the district court to raise the constitutional issue, they withdrew the charge of disability, physical or mental, but they didn't withdraw the penalty, which is still in effect. I must say, I still have trouble trying to understand the motivation. Of all the theories I've heard, the most likely is that my colleagues want to eliminate my dissents, for it embarrasses them when the Supreme Court adopts my dissents, which they do over and over. Most recently, just this year, they adopted my dissent in a veterans case, a case that my colleagues had decided en banc in order to overturn the panel opinion, which I wrote. So I wrote a dissent from the en banc decision, and the Supreme Court adopted my dissent unanimously, and in fact wrote quite an elaborate opinion. It was the interpretation of the Veterans Education Statute, purely a matter of statutory interpretation. But when the Supreme Court overturns an en banc circuit court, they have, as a matter of the culture, I suppose you'd call it, go into detail. So they did, in pointing out in many pages what a bunch of dummies my colleagues were. So this, I think, did not help in my trying to endear myself to my colleagues. But, and also, all of these activities going on are really why I refuse to quit. I cannot leave on the judicial record the substance whereby the judges can, of their own, not going through any statutory procedure, not raising any impeachment question, and not raising even a colorable, plausible objection on any ground, can remove a colleague from judicial service. I must also say that this action does make me wonder at the jurisprudence of my colleagues, and I do want to talk a little bit how we fit, and this court fits, in all of the areas with which you all are concerned. The Federal Circuit is unique in that our rulings they bind every district court in the nation, not just a smaller circuit tribunal. I keep thinking of the optimism and the enthusiasm with which the Federal Circuit was formed. It was 45 years ago that the nation's technology industries, including, I think, probably all of us here, united in order to obtain what we thought was critical, a national court to review all patent appeals wherever the case was tried from every district court in order to provide a stable, predictable, reliable jurisprudence on those issues which come to court, with particular emphasis on patent validity, but also infringement. All of the other aspects that all of you go through every day, in the end, depend on whether you will have the opportunity to proceed with the developments that you've invested in. This history of the formation of the court has been written many times. I recently summarized it in this winter's issue of the AIPLA Journal because it was their 125th anniversary and my 40th year on the court. And the background, the history is what I continue to think about as I look at what has happened over these decades. The 45 years ago, it was all started by President Jimmy Carter, who inherited a nation that was in recession after the Vietnam War and a lot of other reasons. Industry was slowing down. At that time, I was much involved with the American Chemical Society, and we were very much disturbed by what we called the mass layoffs of scientists and engineers as investment in science and technology dried up in the overall culture of the nation. And so President Carter formed at the highest levels at which these things operate a commission to undertake to understand industrial innovation. And it wasn't just the patent system, it was technology in general, and what, if anything, the government could do to remedy and relieve the recession that he inherited when he became president. And so he formed a commission to look at every aspect that anyone could think of. There was a commission to study tax aspects, which eventually came up with a certain tax subsidy. There was a commission on regulatory aspects. They focused on the antitrust and the SEC and other regulatory programs. There were 6 separate committees. Number 6, the last one that was formed, and I've always thought that it was almost an oversight related to the patent system. And they staffed these commissions with the people that they felt were in leadership positions of one sort or another from every contributor that they could think of. Of course, there was technology-based industry. There was government-supported NIH and other research. There were research-dependent technologies and, again, industries and institutions. The Commissioner of Patents was a member. The Academy that teaches patent law and related aspects, particularly antitrust law, were well represented. There are a number of research directors. There were some litigators, and there were the presidents of various patent law associates. I was a member, and I assume the reason that I was a member was because at that time I was the president of the Pacific Industrial Property Association of Japanese and American companies, and the chairman was Bob Benson, who was chief patent counsel for Alice Chalmers, and at that time was president of the AIPLA. So we got together we argued with each other for 2 years. I should say also included were representatives of various public interest groups. The philosophy that we all know that monopolies are bad for the nation, and expressed deep concern about the price of drugs even then, and all of the other things that have continued to concern our culture in the innovation technology field. And there was no dispute before the group. We all understood that to the extent that the patent system does provide and can provide an incentive to industry, to investment, to research, to all of the commercial aspects that go with innovation, that the patent system at one time was a much more effective background for all of this. And we knew where the fault was. We knew that the fault was that because of the structure of judicial review in patent disputes, patents had lost their focus. They had lost their reliability. They had lost their position in the nation as, according to the Constitution, to promote the progress of science and the useful arts. The reason was easy. There were some circuits that seemed to understand how industry worked and how patents worked, and there are some that had an ideological fix that was the other way around. There was one circuit, I think it was the 8th, that for the survey that we made, which went back 40 years, then from 1978, had never sustained a patent. So they were a very logical and desirable forum for those who, for one reason or another, wanted to remove a patent that existed. So of the several remedial steps that this group initiated after 2 years of vigorous debate with each other, plus collecting of information and statistics and anything else that we thought we needed to know, it led on the patent side to 3 major aspects of litigation. First was the Bayh-Dole Act, which was enacted, went through the congressional hearing legislative process. The next was the Hatch-Waxman Act, which, again, from these, I think it's apparent to all of us that even then the nation, the leaders in the patent area, had a strong sense that it was the biological, pharmaceutical, chemical area that had suffered the most disincentive just because of the nature of the research that we do, the costs of development, and the temptation, if you come up with something, to others to see if they can get a piece of the action. So the third recommendation, major recommendation that we came up with was that we get rid of all those dumb judges in the regional circuits and have decisions in patent cases made by people we trusted. We were thinking of the CCPA, the Court of Customs and Patent Appeals. We had Judge Rich, who had written a beautiful patent statute in 1951 that was not, we thought, being appropriately respected. There was Judge Markey, who was very wise and very savvy, and others on that court who knew what they were doing. Again, the story of the formation of this court has been written many times. It was far from smooth, but it nonetheless ultimately came to pass in the structure that we now have. In order to overcome Congressman Kastenmeier, who was chairman of the House Subcommittee of the Judiciary that related to judicial structure, would not support our request to the extent that we were proposing that there be a specialized court. He had experienced nothing but bad luck with specialized courts. Apparently there had been a railroad court that was taken over by the railroads rather than the people it was supposed to serve. There had been a specialized court to implement the oil and gas price controls in the Nixon administration, and that was, I think everyone agreed, a disaster, in part because of the way it was structured, that they were just given the narrow issue of oil and gas price controls, which invariably was part of a larger issue involving lots of big companies. And so it took 7 or 8 years going back and forth for any piece of litigation to be resolved. But when, now I'm going to mention Professor Daniel Metter of the University of Virginia. He was the one who suggested that all we had to do was to combine the CCPA with the Court of Claims. We would then have an unspecialized court, because if you looked at the combined jurisdiction of those courts and then counted all of the patent cases, presumably reasonably within the circuit courts, patents would have been 14% of the jurisdiction, and therefore certainly not a patent specialized court with all of the intellectual deficiencies that specialists are presumed to be subject to. So there was testimony, there were hearings. We on the patent side who supported the formation of this new combined court made a large point out of our observation, our knowledge that judges just didn't understand how patents worked in industry. Again, I was struck by one of the last comments this panel made a few minutes ago was exactly that. And to my distress, I discovered that that was true. The result, of course, of this lack of understanding was the variation in judicial decision. Well-meaning judges, smart about a lot of things in the law, but didn't understand how patents worked, and now, at last, we'd gotten rid of them, gotten rid of all of them. And meanwhile, if you cast your mind back to this era 40 or 50 years ago, ancient history, I guess, to most of you, that science and technology was making astonishing breakthroughs in building on the knowledge and experience of post-war investigations and inspiration, and again supported by the GI Bill, which sent any veteran who wished to go to school and to college, and all of these very smart farm boys turned up getting degrees in science and engineering, graduate school. I went to graduate school and my class was full of veterans who, all of whom said that they just could not have gone through all of this, changed their entire life and family life, but for the GI Bill. Again, this is in the forefront of my mind because this year that the Supreme Court decided correctly had to do with a modern GI Bill. So what we had in mind, we who were much involved with the formation of the Federal Circuit, was that all patent disputes would be decided by wise and savvy judges like those who were on the predecessor courts. The design of the Federal Circuit that evolved was a novel structure in the federal judiciary because it was the only federal circuit court that took appeals from all of the district courts and whose decisions applied throughout the nation. The concern, what turned out to be a concern today, in my eyes, is that there can be no circuit splits because there's no other circuit to decide any patent case. Let me mention one aspect as the supporters of this change persuaded Congressman Kastenmeier for the House and then the Senate to consider this proposal and to hold hearings. It was universally opposed by the American Bar Association, powerfully opposed. They brought to the hearings some of their most famous litigators to explain why this was a terrible idea. Those of us on the other side, I testified in favor of forming the court, were very impressed by the powerhouse of people who thought that they knew everything and that what's wrong with letting a few circuit judges make a mistake, the Supreme Court will fix it. Their position was that the history of the United States Circuit Court system may indeed lead to circuit splits where some circuits go one way and some go the other way on the identical legal issue, which then, and I think even now, is in general a red flag to the Supreme Court, an incentive that it should be looked at from the overview, the view of the national policy, of the people served by the law, the wisdom and the integrity behind certain enactments of Congress to be brought to bear through judicial overview. And so they were quite perturbed. They hired a full-time lobbyist to help them, a person who had been the chief counsel to the subcommittee on courts of the House Judiciary Committee, to explain to the rest of the Congress, House and Senate, who needed to enact the formation of the Federal Circuit, to explain what a bad idea it was. Against them was the industrial might of the nation, the people who favored all of this, from mostly the bar associations, obtained industry signatures on the testimony that I presented. 170 of the nation's largest industries told Congress that we need this court. Things are bad. It looks as if they may get worse. We need a uniform court of wise and savvy judges who understand how business works, how commerce works, how inventions are made, and who will come forward and get it right. And we prevailed. However, I do have to report that much has changed since the Federal Circuit was formed. For the first decade or so, the circuit was credited with getting everything so completely correct that the patent system was pulling the nation out of recession. And we coasted on that glory. I think it probably was true. The decisions of the early court were excellent. There were some commentators that we didn't get any attention from the Supreme Court, but it was pretty clear to me that we didn't need it because the judges got it right. But things started to slip after maybe the first 2 decades. That led to another 10 years of argument in a different forum, the argument that led to the PTAB, the transfer essentially to an administrative agency of what the judges had been doing. The general sponsor of that concept was the Department of Commerce, the then Commissioner of Patents, who was essentially, according to the legislative record, which is all that I've read about it, Commissioner's name was Judas, and he insisted that unless there was an estoppel provision, the government, the Commerce Department, and the President would not support the formation of this administrative tribunal called the PTAB. And after a lot of back and forth, a good many compromises along the way, everyone in the private sector thinking that since the judges were getting it wrong, the people who examine the patents at least are more likely to get it right and to try and rebuild the euphoria that existed a decade earlier as far as the patents incentive was concerned. So again, this is an example of those who are involved, those who are most concerned, taking initiative to make a change. Here we are, and this is the message that I thought to use this time to communicate, that you in this field who understand the new technologies that we're coping with, as well as those that have already existed in your field of interest, to understand how these technologies and their commercialization, their development, and their bringing to public use, how this serves the nation, in order to assure that the law serves the technologies and the industries and the effort, and not only that, but provides whatever incentive follows from confidence in a reasonable, workable law. I must say my comments, my belief that perhaps the ABA was right in their position that there was no really valid reason for taking this one area of litigation away from the regional circuits. The regional circuits refused to part with the copyright and trademark and trade secret jurisdiction, which is primarily theirs, except that the statute allows those issues to tag along if there's a patent issue. But that the idea of allowing, if there are circuit conflicts, everyone appreciated that the circuit conflicts were based on philosophy and ideology. I, for one, thought it was lack of understanding of commerce and all the rest of it. I still think that that was correct. However, the ABA's position that these societal balances should not be made by a circuit court of judges who don't even go through the full advise and consent process like the judges of the regional circuit, that they should have the last word. And things have not stood still. The PTAB changed a good deal of how patents are adjudicated and how they survive. Part of the problem, my concern, is that the Federal Circuit may not have followed along in providing the stability that they were supposed to provide. I read increasing criticisms of the Federal Circuit with which I cannot disagree. Our most recent decision, just a couple of months ago, was an in-bank decision on design patents, which seems to me to contain some flaws. However, it was remanded, so it's hard to tell how final that would be. But the position that the Federal Circuit took in overruling 40 years of design patent precedent seemed to me to be strange and to be curious. And again, now that my colleagues have removed me, at least temporarily, from the bench, I had no opportunity to state what I thought at the time that decision was issued. I think it was May this summer. What we need in our nation is an optimum adjudication structure. The last time, some years ago, some academic had a round table as to whether there were things that need to be changed and improved in a dramatic way. And the general consensus around that table was that things were okay the way they are. This was before the PTAB. I want to encourage you in this room to understand that these aspects are not out of our control. They are powerfully within the control of those who are involved. There are mechanisms to find one's way through the system, to look for congressional hearings, perhaps to encourage an administration to establish something like the President Carter Commission in 45 years ago, to decide if your experience is that things are not as right as they could be, that there are remedies to be sought, and to find the appropriate best remedy, that it's not out of our control, the other way around. It's something that we can all affect and act on, and being encouraged by Jane's smile as a rabble-rouser. This in some ways, because there were rabble-rousers at the time of Carter as well, but to look and see where we are and to do what we can to get it right. So that's the message that I'd like to leave with you. If there's anything else you'd like me to talk about, I'm glad to, or else we can continue our conversation informally if you like.
I think that was wonderful, Your Honor. I really appreciate you coming and talking to us about that. Yeah, I have sort of been the rebel rouser in chief, I suppose, when it comes to this particular issue, and I just think it's so fundamentally unfair on so many different levels. What I will say, and maybe I'll be a little bit less diplomatic than your presentation was, but what we know for sure is that this entire episode began with a complaint that was filed that was full of inaccurate statements, to be kind. These inaccurate statements were known to be inaccurate at the time that they were filed, and they have never been corrected. So the one thing that I think it's important for everyone to understand is Judge Newman has gone through not one, not two, but now 3 different mental evaluations, all of which she's passed with flying colors, the last of which was a unique and innovative test that not only engaged a mental evaluation, but did a scan of her brain. And the conclusions were that there is absolutely no signs of a dementia or cognitive decline, and in fact, the health of her brain is remarkable. All the rest of us in this room should have such a good brain. It was really a brain scan that the person who did the scan said of someone who appeared to be in their 20s. So we have not only just the anecdotal or the subjective mental evaluations of 3 professionals, but we have a scientific, if we're going to be concerned with science at all, a CAT scan and the reading of that CAT scan and the identification of no abnormalities, that has to matter. And yet, since that happened, the Federal Circuit has continued to have Judge Newman suspended. And it's an indefinite suspension, and that's unconstitutional. It's indefinite because they continue to leave open the possibility that they will renew it, and which they've already done once before. So this is an episode in our history that has led me to question whether or not we really actually need the Federal Circuit, whether we should have the Federal Circuit. And somebody mentioned to me, is like, Gene, take a look at what the Federal Circuit is actually doing. And not whether you agree with their opinions or not, but what are they actually spending their time doing? And the one thing that became clear to me when I looked, I did a survey of all of the things that they posted, all of the decisions and orders that they posted between April 1st and the end of September. And it's shocking how little patent work they actually do. If you assume that every Rule 36 decision that they make, and add that, it relates to a patent matter, and add that together with the patent precedential decisions and the non-precedential decisions, their patent docket is 24% of what they do. And just the other day, Eileen commented to me, and Eileen's our editor-in-chief, she says, some days it's hard anymore to find something to report on dealing with cases because the Federal Circuit doesn't decide patent cases anymore. On some days, they decide nothing. On other days, it's all Rule 36. On other days, it's mostly veterans. Their veterans' appeals take up an enormous amount of what the court is doing. And the reality is that a very, very tiny, less than 10%, I think it's, and I wrote an article on this so you can check back if you're really interested. I think it's on the order of 6% of what the Federal Circuit does are precedential patent decisions. Okay, now if that's the case, why do we need this court? I'll go one step further than I think I've gone publicly so far. Judge Newman should have, and not to say anything bad about her attorneys have been great and very good to her, but Judge Newman should have the best representation that we could possibly afford her in the industry, and we should all be lining up to give it to her for free. And we can't. We don't. And people in the industry, you know why that is. You know your firms have told you not to get involved, don't take a position, don't come out. So we have a court that not only is specialized, but it has captured the industry. Because we all know that, and I can say this, right, because I'm already on the blacklist. We all know that if you stand up and defend Judge Newman in this situation, whether it be in court or just publicly in a forum with a microphone and a camera, or whether it be in a filing, that you will be on the blacklist at this Federal Circuit. People that know Judge Moore know that to be the case. And frankly, I said this when this whole episode started, that the ultimate conclusion of this is far more likely to lead in Judge Moore off the court than it is for Judge Newman to be off the court permanently. So I think there's a lot of things that we in the industry need to start talking about, because clearly this was not the court that Judge Markey and Judge Rich and Presidents Carter and Reagan, bipartisan presidents, created. And it matters. And it matters a lot. And I don't know where this is all going to go, but we're all along for the ride. I think we all have a vested interest in this. And I'm not going to ask anybody to do anything that's going to ruin your career or hurt your clients. But I do think we need to have a thoughtful and intelligent conversation about whether or not the Federal Circuit that we have today is the Federal Circuit that we were intended to have, the Federal Circuit that we need, and the Federal Circuit that we really should tolerate. Because it has become, I think, an embarrassment to the federal judiciary. And that's really all I have to say at this point. Your Honor, if you have any final remarks, please feel free to make them. Don't feel obligated. We can go and talk over some hors d'oeuvres if you'd like. And but if you have final thoughts, we'd love to hear them.
Well, there is so much background and detail underlying what Jean has just commented on, most or all of which I find extremely hard to comprehend and that needs exposure. I hadn't thought that this would last very long. As soon as I told, when the chief judge told me that I was physically disabled, had a heart attack and fainted in the courthouse, and was hospitalized for insertion of a stent, and I announced that I've never had a heart attack. Is this wood? I always knock wood when I say that. I've never fainted in the courthouse. It's astounding that nobody knew I had fainted in the courthouse until the chief judge told them. And I had no stents, and although I wasn't looking to go and get myself a full-body CAT scan to prove I had no stents because I never had a heart attack, but I offered. And all of these things, and yet that was published, that I was physically disabled on the court's website, and was never withdrawn, that was never corrected. Eventually, after I filed the action in the district court on the Constitution to say that the disability process was unconstitutional, and the district court, as a published opinion, said, no, the process is not unconstitutional, and this judge declined to take up how it had been applied to me. There is a disability statute that allows judges to act against a colleague, provided that the action is moved to a neutral forum and the complainants are recused. However, the Chief Judge of the Federal Circuit has refused the move to a neutral forum, and the Supreme Court's committee sustained that refusal and never looked at the merits. That's just a little bit of some of the extraordinary, I think, nastiness and worse is the word that's going on, which I still can't understand in terms of all of the people who I once thought were my friends, reasonably smart enough, on the court. And I have been told by more than one person that when they have an action, if they can possibly style it as a trade secret action and ignore that there's a patent involved, or as a copyright or even trademark action, and leave out the patent count in order to avoid the Federal Circuit. And this is just the contrary of what I and the rest of us believed with our high hopes for a court of wise and savvy and brilliant people with industrial understanding and experience to fix everything. So that was a long answer to a short question.
No, very good, Your Honor. We really appreciate you being here, and we hope you will join us for some social hour here now. But thank you so much, Your Honor.
Absolutely.
That was great.